Ratio Decidendi and Obiter Dicta are the two legal maxims which governs the very provision of precedent. While ratio decidendi means those principles or rule of law established and settled by the superior court in a decided case or in a judgment which should be followed by the inferior or subordinate courts in the similar nature of cases, while obiter dicta is a kind of observation, that observation made by their lordship while delivering judgment in a case, and such legal observations are not binding over the subordinate or inferior courts, while ratio decidendi is a binding authority over all subordinate courts and inferior courts. In England, obiter dicta is not a binding provision of precedent to be followed by the subordinate courts or inferior courts in England. But in case of India, we found both ratio decidendi and obiter dicta are almost binding over all the subordinate and inferior courts in India. So regarding obiter dicta, as it is followed in Indian legal system, we found certain leading cases relating to the position of obiter dicta. So one of them is Mohan Das, Ishwar Das versus Satnathan in 1955, Basant Kumar versus the chief engineer and others in 1956, then the Municipal Committee of Amritsar versus Hazra Singh 1975. In those above cases, almost the high courts expressed that the obiter dicta or the legal observation made by the Supreme Court could be binding over the high courts, as previously the obiter dicta or legal observations of privy councils were binding over all the high courts in India. So almost all the high courts in India, they have agreed on the position of obiter dicta. So their expression that the legal observation made by the Supreme Court in the concerned judgment or in decided cases shall be binding over all high courts in India.